Well, good afternoon everybody, and thank you very much for joining us today. My name's Anthony Morris and my co-presenter is Stephen James. We're both partners here at the dispute resolution team in Clarkslegal. Now that of course means that we tend to experience the negative side of things and get called in when things have gone wrong. But our aim today is very much to give you a practical guide to your duties as a director and some tips on how to ensure that you avoid problems in practice. Now, in the time available, unfortunately, we can't cover everything and give you comprehensive guidance. So if there's anything that you'd like to ask us as we go through, then please complete the box on the screen as follows, and then we'll endeavour to answer you at the end. And if for some reason we haven't got time to do so, then we'll endeavour to come back to you later on after today's talk. I just want to start by saying a few words about companies and limited liability. Every company has its own legal identity and is capable of entering into agreements and trading just like any other natural person. A company may own and deal in property, it can contract on its own behalf, and it can sue and be sued in its own name. Its legal personality is entirely separate from the legal personalities of its directors and of its shareholders. But the law recognises that a company can't act on its own, it must act through human beings. It doesn't have a mind of its own. So in practice, decisions made by directors and actions taken by them during the ordinary course of business for the company are treated as decisions and acts of the company itself, and the director won't normally be personally liable for them. However, whilst the laws preserve the limited liability status of companies themselves, so that in only very unusual circumstances can someone bring a claim against shareholders, the position of directors has been increasingly modified by the law. So whether it's in relation to insolvency or health and safety or directors' duties more broadly, the law has recognised that there will be circumstances in which directors need to be accountable for their acts and indeed for their omissions. It's very easy to become a director and immediately therefore to become subject to a broad potential range of liabilities. This may seem daunting, but hopefully we can explain today ways in which a well-informed director, acting sensibly in the course of business and seeking advice when difficulties arise, should have no real cause for concern. So I'm going to now hand over to Stephen, who's going to start by talking about who is and who is not a director.
Thanks, Anthony. Yes, I thought a good place to start today is to ask ourselves, who's the subject matter of this talk? Who is a director? And you might say, well, that's pretty obvious. We all know who a director is. Well, sometimes it can be a bit more nuanced than that. There's some terms up on the screen here. A de jure director is what everyone would understand as someone who's been properly appointed. They filled in all the forms, they're filed at Companies House. If the world at large searches at Companies House, they can see this individual is a director of a company. They participate in decisions, they're on the board, they're held out by the company as a director, and they call themselves a director. So there's no question that person is a director. And everything I'll be talking about today applies to those directors. However, there are two other categories I want to mention. A de facto director. This is someone who is presented by the company as a director and probably holds him or herself out as a director of the company. And for whatever reason, they weren't validly appointed. So if someone was searching in Companies House, they wouldn't see this person. In those circumstances, the chances are they'll be treated as a director for pretty much everything that Anthony and I will be talking about this afternoon. The third category, a shadow director, is something quite different. As the term suggests, it's someone who's in the background. They don't call themselves a director, and if you ask them, they would probably deny they were a director. But in reality, they're pulling the strings in the background, and the company is doing what this person tells the company to do. The law decides that in those circumstances, the person should be treated as a director. They're called a shadow director, but in reality, they're subject to all the duties and obligations that Anthony and I will be talking about today. Now, one further bit of terminology before we get into the meat of the presentation. Executives are full-time positions, and non-executives typically part-time, perhaps a day or two a month. For the purposes of this presentation, there's no real distinction to be made between them, they're both subject to directors' duties. Okay, so what are the duties? These have arisen over many, many years and traditionally have been referred to as fiduciary duties. But more recently, they've been codified under the Companies Act and they can be conveniently found in one place. And here are the 7 duties, and I'll tell you briefly what they all mean. The first one, to act within the company's powers. This is twofold. It means a director can only do what the company is permitted to do, acting in accordance with its constitution, its memorandum and articles of association. These may be standard or they may be amended specifically for the company. And the second element of this is to exercise those powers for a proper purpose. And this is a subjective thing. You have to look at why the director is doing something, look at his motives, and are those motives proper. Duty number 2 is to promote the success of the company. Now, this is hugely vague on its face. It covers a broad range of things potentially, but we have some guidance from the law, and a director should consider the likely consequences of a decision that he or she takes, the interests of the company's employees, the need to foster the company's business relations with suppliers, customers and others, to consider the impact of the company's operations on the community and the wider environment, the desirability of the company maintaining a reputation for high standards of business conduct, and also to act fairly between the company's shareholders. So there's lots of the directors to think about. Next duty, to exercise independent judgment, essentially is showing that the buck stops with the directors. The directors can't abdicate their duty, and they must make final decisions themselves. This doesn't mean that they can't take advice, and in fact in lots of circumstances it's appropriate for directors to take advice, but ultimately the director has to exercise their own judgment in deciding whether or not to follow that advice. Duty number 4 is to exercise reasonable skill, care and diligence. This has 2 standards. As is often the case in the law, there's an objective and a subjective element to this. Well, all directors have to live up to a particular minimum standard, and then we will consider any additional experience or expertise or qualifications that a director has, and that goes into the mix. And if it means that raises the bar for the standards they have to obtain, the director has to bear that in mind. Next duty is to avoid conflicts of interest, and this is something that Anthony is going to be focusing on in a minute or two. Duty number 6 is not to accept benefits from third parties. Now, these are benefits that are offered to a director in his or her capacity as a director. The obvious example would be a bribe, but it can be more subtle than that. It's the sort of thing where if it feels wrong, it probably is wrong, or if you'd be embarrassed telling someone else about it, the chances are it would be in breach of this duty. And the final duty under the Companies Act is to declare an interest in proposed transactions. So if a director has some sort of personal interest in what the company is doing, the director must tell his or her fellow directors about that before the transaction itself goes ahead. So now we've talked about what the duties are. I'll spend a minute or two saying what happens if those duties are breached. An important starting point is that these duties are owed by directors to the companies. They're not owed to shareholders, to creditors or the world at large. So if a director breaches those duties, it's the company that has a claim against the director. And the company in those circumstances has a range of potential claims. It could seek damages from the director for the loss that it suffered because of the breach. it can have a transaction entered into by a director in breach of these duties declared void, essentially cancelled, or it can seek an account of profits that a director has unfairly made as a result of breaching his or her duties. Now, I said that the duties are owed to the company, and there's a slight twist on that. Sometimes a director will not take action against, a company will not take action against its directors. This would typically be where the directors who have breached the duties have control of the company's board, and they're unlikely to be persuaded to effectively sue themselves. In those circumstances, the company's shareholders can seek the permission of the court to bring what's called a derivative claim. And the court can give permission for the shareholders to essentially cause the company to bring a claim against the directors who've done something wrong. This is a fairly unusual claim, and it's a challenging one for the shareholders to bring, mainly due to legal costs. The shareholders have to fund the action, and if the claim succeeds, the benefit of the claim, the damages received, go to the company rather than to the shareholders directly, so it might not be suitable for the individual circumstances. So I'll hand back to Anthony now to talk in a little more detail about conflicts of interest.
Thank you, Stephen. Well, Stephen's outlined the various duties of directors which have now been codified by the Companies Act, and I just want to focus in a bit more detail on conflicts of interest. By way of reminder, there are two key conflict duties. The first is the duty to avoid conflicts of interest, that's section 175 of the Companies Act. The second one is the duty to declare interest in a proposed transaction involving the company, that's section 177. Now, although there's been legal argument in the past, it does now appear beyond any doubt that the test of whether or not a director is in breach of this duty under section 175 and 177 is objective. And in practice, that means the court will form its own objective view on whether the duty's been breached. It doesn't depend on whether the director was aware that what they were doing was in breach of their duty. Indeed, the honesty or otherwise of the director is irrelevant, as a director can be in breach of this obligation even if they've acted in good faith. And as Stephen mentioned earlier, directors with particular expertise may be held to a higher standard. Now, examples of conflict of interest in practice are very varied. One of the formative cases was Industrial Development Consultants and Cooley, and it's worth having a look at the facts of that case just to understand how conflicts arise. This is a case dating back to the 1970s. Mr. Cooley was the managing director of a construction company, and that company failed to obtain a valuable contract to do building work, in fact to build 4 depots for the local gas board. Mr. Cooley, the managing director, was an architect by training, and in fact he had formerly been employed by the gas board. After the company had failed to get the business from the gas board, it seems the gas board approached Mr. Cooley personally and directly to ask him to take on the work himself. He didn't tell the company about this, and instead he told the company that he was ill. He procured his release from employment and then went off and did the work himself for his own benefit. Naturally, when the company, IDC, found out about this, they were pretty unhappy and they sued him for damages. And the court took a dim view of what Mr. Cooley had done, and it found him in breach of his duties of not being in conflict, and it ordered him to account to the company for all the profits he'd made on the contract. And the outcome seems fairly straightforward, but one of the interesting points is that the company would never have made those profits. It would never have made the profits because it would never have got the contract, and that was the evidence. But nevertheless, the court wasn't prepared to allow Mr. Cooley to retain the fruits of his conflicted behaviour, and it was particularly unhappy about the fact that he'd lied about his health to procure release from the company. And that sort of attitude of the courts really can be seen in most of the cases since then. And the diverting of business opportunities in this or similar ways happens very frequently in practice. So I'd say that any director who's thinking of moving on always needs to take care not to act in a way that diverts business or diverts a maturing business opportunity from the company of which is a director. Other examples of conflicts are obviously contracts which benefit a director personally. That's a fairly obvious potential conflict. Sales from or to a director, or indeed the director's own service contract. But other situations are less clear-cut. Typically, these may be where a director has an interest in a supplier or a customer, or possibly a family member is an employee or shareholder in such a supplier or customer. All of these can give rise to a conflict of interest. So what should directors do in practice to ensure they don't fall foul of these conflict rules and the quite severe penalties that may result? Well, I think there are 5 key tips that I'd suggest. The first is ensure that all your directors are aware of their duties. Self-evident, but many aren't. Maybe get them to listen to this webinar later on. Secondly, consider asking directors to complete questionnaires on a regular basis. This has become quite standard in many organisations, asking directors perhaps on an annual basis to identify any interests they've got that may conflict with those of the company. Thirdly, it's possible to authorise a conflict in advance if it's properly declared, and that is quite a common way of dealing with conflicts which inevitably do arise from time to time in businesses of all sizes. Fourthly, if things have gone wrong and there has been a breach of duty, it's still possible for the shareholders to ratify that breach, although particular rules have to be followed, and neither the director concerned nor anyone concerned with the director, connected I should say with the director, can take part in such a vote. And finally, worth bearing in mind, a company can purchase insurance for its directors to cover liability for breach of duty or breach of trust, and that can certainly assist. So I'm now going to hand back to Stephen, who's going to talk a little bit about directors' liability for company debts.
Thanks, Anthony. Well, the whole point of companies is that they have limited liability. And that means that the company is liable for the debts and no one else. But that's not always the end of the story. And just look at a couple of examples of situations where third parties potentially have liability for company debts. I'd say the starting point is that, and this is the end point for the very large majority of cases, that there is no liability, primary liability, on a company's directors or its shareholders for a debt owed by the company. And this extends to parent companies, sister companies, subsidiary companies. They all have their own individual personality and their individual liability for their individual debts. In practice, particularly with start-up or smaller companies which don't have a large asset base, landlords, banks, suppliers will ask for guarantees or indemnities as a condition of entering into a lease or an overdraft or a supply agreement. And in practice there may be no alternative to that, but the terms can be negotiated and the particular director giving the guarantee knows where he or she stands. One phrase that comes up from time to time is the corporate veil and piercing the corporate veil. And there's a sort of idea that somehow the individual liability, personal liability of a company can be disregarded. And that's really not the case. And I'm going to mention a reported decision, Prejudice Resources Limited in press, to explain why. This is actually a matrimonial case, and it's involved a divorce settlement. And the husband was ordered to pay a very large amount of money to his ex-wife. I think it's something like £173 million. And it was common ground that the only way this could be done would be if the husband were ordered to transfer to his ex-wife properties owned by his company. And his wife applied to court and said, well, you can pierce the corporate veil, you can disregard limited liability, etc., and make an order that those properties come over to me. And the case went all the way to the Supreme Court, the highest court in England and Wales, and the court disagreed. It's confusing actually, because the wife actually won the case for different reasons. But when the court considered what the corporate veil meant, it didn't apply in these circumstances. It doesn't give carte blanche to ignore the individual personality of companies. And the court said that the corporate veil applies in two situations: concealment and evasion. Concealment simply means that a company isn't really the owner of particular property, it's just pretending to be, and the true owner is someone else. So it doesn't really apply. The second is evasion, and that's where, in these circumstances, for example, had the husband put his properties in the name of the company simply to prevent his wife getting at them, then that transaction could be reversed. But there's no general principle that the assets of the company should be available to the world at large. The other point to bear in mind is this is a case where a third party was trying to enforce a debt against the director by looking at the company's assets rather than the other way round, i.e. Enforcing a debt against the company by looking to its directors. So there's nothing particularly that directors should be concerned about if anyone ever mentions to them piercing the corporate veil. Moving on now to litigation costs. It's a sad fact of life that litigation is expensive, and often when you get to the end of it, there will be a concern about whether your successful judgment and costs order can be satisfied. And in those circumstances, the successful party who can't get the company to, the losing company to pay up because it hasn't sufficient money, will look to third parties potentially and seek what's called a third party costs order. And I'm going to mention another case here which helps show the principles that the court employs in those circumstances. Deutsche Bank and Sebastian Holdings was another very large piece of litigation. Deutsche Bank sued a company and it successfully obtained a judgment for $243 million. Now, it spent a lot of money getting there. Apparently its legal costs were £60 million. Sadly for Deutsche Bank, Sebastian Holdings didn't have enough money to satisfy the judgment and the costs order in full, and it turned its attention to Sebastian Holdings' sole director and shareholder. And it successfully obtained a third-party cost order against the director and ordered that an on-account payment of £36 million be made by that director. And what the court considered when reaching that decision was who was the true party to the litigation, who was running the litigation and for whose benefit. And in these circumstances, it was the individual director and shareholder. If he succeeded, if Sebastian Holdings succeeded in the litigation, he was the one who would really benefit from it. He was personally funding the litigation from Sebastian Holdings' side, and he was telling the company what to do. So taking all those circumstances into account, he fought the litigation, gambled and lost, and it was only fair that he be ordered to personally pick up the tab for all the enormous costs that Deutsche Bank had incurred as a result. There's one point I should mention about what are called pure funders. Simply paying for litigation or helping with the cost of litigation doesn't mean that you will incur personal liability. The usual example in practice is where perhaps a family member, just because they're keeping good family relations, love and affection, will offer to pay someone's litigation costs. As long as they don't have any personal interest in litigation and they're not saying how the litigation be managed, it's very unlikely that that family member will incur any liability as a result of contributing to the litigation costs. I'm going to move on now to talk about an additional range of duties that directors must consider when times get tough if a company is threatened with insolvency. And the first of those is wrongful trading. Now, the test for wrongful trading is that when a company reaches a point where there's no realistic prospect that it's going to avoid going into insolvent liquidation, the directors then must do everything they can to minimise the liabilities of the company's creditors. Generally, that will mean closing the company immediately, particularly if the company is losing money. In some circumstances, it might mean continuing to trade for a short period of time. For example, if a contract is nearing completion, and that will mean a substantial payment into the company. If directors get this wrong and continue trading after they really should have closed the doors, a subsequent liquidator can seek an order, and if successful, the directors can be ordered to contribute to the additional losses that the company suffered as a result of that continued trading after the time when it really should have stopped. Something that's quite similar to wrongful trading is misfeasance, and sometimes misfeasance and wrongful trading applications are brought hand in hand. I've called it a sweep up of general wrongdoing because the definition in the Insolvency Act is quite extensive. But it talks about misapplying funds received by the company. It talks about breaching duties, particularly the duties we've spoken about earlier in the Companies Act. And again, if the liquidator succeeds with a misfeasance claim, directors can be ordered to contribute personally to the debts that the company has incurred. Whilst we're on a rather gloomy note, I'm going to mention one or two other insolvency issues, but quite quickly. Transactions at an undervalue are where a company, before it went into liquidation, got rid of its assets for less than their true value. To give a simple example of that, directors of a company may decide to sell themselves their company cars shortly before liquidation, but less than the true value, the true book value of those cars. And in that case, the liquidator can seek an order that the directors pay the shortfall between what they actually paid and the real value of those cars. Preferences will be where a company pays off certain creditors in the run-up to liquidation in priority to others, and it is particularly if the company pays creditors who are connected with the company, such as the directors themselves. So an example of this in practice might be the directors causing the company to pay off the directors' loan accounts in the run-up to liquidation, or more subtly, perhaps, to pay off a company overdraft where that overdraft is personally guaranteed by the directors. So although money isn't directly being paid to a company director, the consequence of that payment is that the director unfairly benefits because their liability under the guarantee has fallen away. The third point I want to mention quickly is disqualification. Directors and administrators are obliged to file a report with the government on every job that they take, and to consider whether the conduct of the directors causing the liquidation or administration has fallen below the certain necessary standard. And if it has, an action for disqualification can be brought against those directors, and if proven, the directors can be disqualified from acting for a period of between 2 and 15 years, depending on the seriousness of their breaches. So that's all the bad stuff. What can directors do to ensure that they don't fall foul of any of these points? Well, as Anthony said, sensible directors really should have nothing to worry about anyway, and all these provisions I've been mentioning are really to catch the rogues who don't operate by the fair and reasonable regime under the Insolvency Act. But there are some things that can be done in practice to help the position should directors ever find themselves in the unfortunate position of being on the wrong end of one of these actions. And it's important to appreciate that a liquidator has 6 years in which to bring a claim against directors, starting from the commencement of the liquidation. So once you add on a little bit of time running up to the liquidation and time for the litigation itself, it could be perhaps 7 or 8 years after the event in question when it's actually being tested in court. And over that period, witnesses may no longer be available, memories have faded, and it's much more difficult to justify a decision that seemed perfectly reasonable at the time. And to guard against that, it's really very important to keep a clear record of decisions, and particularly why decisions were taken. That will often mean keeping proper minutes of board meetings, particularly, it sounds odd, but particularly for sole director companies, to minute a decision that a sole director takes, so that can be used as evidence to justify a decision many years later. Alongside this, the directors should make and keep updated realistic financial projections on a regular basis. To do this for the short and medium term, to show that the company remains a viable business. Directors should think about taking professional advice. This might be from an insolvency practitioner, an accountant or solicitor, to note that advice and, where appropriate, to follow it. Finally, directors mustn't assume that because they're not involved in the financial part of a company, they don't owe duties. That would be quite wrong. For example, a manufacturing director would be very much the target of a wrongful trading action if all the other criteria were met. It's not an excuse to say that he or she was not involved in financial decision making. All directors must concern themselves with what the company is doing and get involved in the decision making. I want to wrap up my section of today's presentation by talking a little bit about contempt. In this context, I mean legal contempt, contempt of court, and to ask the question whether directors can simply ignore court orders that are made against their company. Well, there are 2 examples I have here of directors who did just that and paid the price. I put court order there. It's important to appreciate these are injunctions, and I'll give you the facts of the 2 cases. Phonographic Performance Limited was a case that involved an injunction against a nightclub that didn't pay the appropriate licence fees for playing music. The injunction was served on the company, ordering it not to play the music. It continued to do so. The Phonographic Performance Limited issued contempt proceedings against the company and its director. The director ignored those. The company continued to play the music. It came to court, and the director and the company were found to be in contempt at court, and the director was sentenced to a custodial term. Now, the important thing is that the director wasn't personally playing the music. The breach of the injunction was by the company. But the company willfully ignored the injunction, and for that reason he paid the price. Navigate Chemicals Paul Inc. Had similar themes, but this involved a freezing order. A freezing order freezes the assets of a company, but it also requires the company to give details of its assets. And the respondent company, Newtec in this case, again ignored the order and didn't give details of its assets. Contempt proceedings followed, and again the directors ignored it all. In fact, one director resigned very quickly and was replaced by another director. The court was pretty unimpressed with all of this. It felt it was clear that the directors were simply ignoring what was going on and treating the court with contempt. It also considered that the director who resigned remained as shadow director, who you'll remember is someone who operates in the background and pulls the strings effectively. So he remains subject to the general duties of directors. And the two directors in question were imprisoned respectively for 18 and 12 months, which of course shows the seriousness of falling foul of contempt. Okay, I'm going to pass back to Anthony now to talk about health and safety issues.
Well, thank you very much, Stephen. So we're going to switch to a very different subject now, which still impacts on directors, and that is health and safety and its regulation. Now, the main law relating to health and safety is contained in the Health and Safety at Work Act 1974. But beneath the Act lie an extensive set of statutory regulations. These place a very wide-ranging set of obligations on employers, and of course a detailed explanation of these is way beyond the scope of today's talk, you'll be pleased to hear. But where the employer is a limited company, the starting point will of course always be that it's the company that's liable for breach of health and safety, and typically that'll be in the form of a fine. These can now be very substantial, in fact, and are typically linked to turnover. But crucially for today's purposes, an individual director can also be held criminally responsible for health and safety offences under Section 37 of the Act, and there are really two conditions that have to be fulfilled. The first is that the company itself must have been found guilty of a health and safety offence, and secondly, the offence must have been committed with the consent or connivance of, or was attributable to any neglect on the part of the director. Now, in this context, consent means that the director had knowledge or awareness of the circumstances and the risks which cause the health and safety failure. Connivance means knowing about the risks but doing nothing about them. And these are very real risks for a number of reasons. Firstly, the potential liability for director is not just fines like the company itself, but of course in very serious cases, potentially custodial sentences. Secondly, as you'll see on the screen, a director who's found guilty of an offence can also be disqualified as a director under the Company Directors Disqualification Act. And in a very serious case, a director can also be prosecuted for manslaughter. Indeed, in 2007, a new offence of corporate manslaughter was introduced so that companies can be prosecuted for that as well. It has to be said that prosecutions of company directors for manslaughter have been rare, mainly because the courts have found it quite difficult to identify who the controlling mind of a company is. But it is easier to do that in the case of a smaller company, and it's believed that such prosecutions are on the increase. And the reason for that is the Health and Safety Executive, the HSE, and they're responsible for enforcing the Health and Safety at Work Act. And they've said in their enforcement policies, which are produced from time to time, that one of their main aims is to ensure that directors who fail in their responsibilities are held to account. So the HSE inspectors have been asked to consider, in particular, the management chain, the role played leading the events leading to an offence of the individual directors within an organisation. And what this means in practice is that if an offence has occurred, the HSE will ask difficult questions. They'll look at not only how the offence took place, but also the organisational structure, roles and responsibilities, the organisation's attitude to health and safety, and more generally health and safety within the organisation and its record. Now, in practice, it's of course almost impossible for an individual director to have detailed knowledge of health and safety legislation, unless this happens to be their remit, or to have detailed knowledge of the entire operations of a business, especially with regard to health and safety. But I think that there are two key things that any director should look at and ensure are in place. And these are, as you'll see on the screen, reporting to the board and defined procedures and policies. In relation to reporting, I think directors should ensure they're kept informed about the company's health and safety risks and performance. I'd say there should be regular reporting to the board from someone within the organisation who's tasked with carrying out risk assessments and assessing health and safety performance. Of course, bear in mind that simply receiving the report isn't enough. If you receive a report and it highlights issues, then there's also going to be an obligation to act. And I should add that if action becomes necessary, then that should be carefully documented so that it can be shown later that you've done so. And the second aspect, define policies and procedures. Any company should have in place clear policies and procedures dealing with health and safety. That would include a plan setting out who has what responsibilities and the management system in place, some sort of monitoring and reporting, some sort of regular review, and you may even want to consider use of an outside health and safety advisor to assist with that task. I think with those two in place, the risks of health and safety breaches will be minimised, and you'll be able to show as a director that you've taken sensible steps to avoid any personal liability in the future. My next subject is very different once again, and it's about the relationship between directors and shareholders and who wins that relationship. Well, the answer is it depends, of course, but directors are ultimately controlled in a number of ways by their shareholders. It may be that there's something in the company documentation, it may be in the director's service contract, there's bound to be things in there, the articles of association or a shareholders agreement, and then various statutory rules, all of which will control how a director can act and how the shareholders may control. But there are a few things which I thought it was worth highlighting. Obviously, usually directors have a power to appoint directors themselves, certainly replacement or additional directors. But the shareholders also have the power to appoint and remove directors unless it's restricted by the articles. Usually there's an express power to this effect in the articles, and if the articles make no provision about appointing directors, then the shareholders will have an inherent power to do so in any event. And of course, even if the company's articles expressly exclude the right for shareholders to appoint directors, they can always go through the hoops to change the articles. So ultimately, they do have control in that way. Shareholders also have a right, under Section 168 of the Companies Act, to remove a director by ordinary resolution, and that can be done at any time. Of course, that doesn't avoid liability for breach of contract or unfair dismissal if they do so in breach of contract, but nevertheless, they have that power and they can effectively take a director off the board when they want to, provided they follow the detailed requirements contained in Section 168 and 169 of the Act for that. And then Stephen's already talked about, in some detail, derivative claims and potential actions by shareholders under those circumstances, albeit those circumstances are very limited. But the important issue for directors in this context really is the possibility of unfair prejudice actions, and I want to spend a bit of time closing on that. This is an important check on the actions of directors, and it's the right for shareholders to apply to court for relief, known as unfair prejudice relief, on the grounds that the affairs of the company are being or have been conducted in the manner that's unfairly prejudicial to the interests of members generally, or some part of its members, or that an actual proposed act or omission of the company would be prejudicial. And this gives the minority shareholders the right, where they wouldn't otherwise be able to regulate the actions of the directors, to take steps to prevent actions which would be prejudicial to their interests. Now, of course, in practice, such actions almost always involve a challenge to the actions of the directors, and normally there's an underlying dispute between relative groups of shareholders. Whilst the courts have on a number of occasions made it clear that it's not intended to provide a route to challenge the ordinary management decisions of the board, they're free to make those decisions as they wish, I think the dividing line in practice can also often be quite unclear, really. And these actions can arise in so many different circumstances. Some examples would be a decision by the directors to pay themselves by way of increased salary or perhaps bonuses rather than to pay dividends to shareholders, which of course then prejudices non-director shareholders. That's quite a common event. It may involve a specific transaction which in one way benefits certain shareholders over others. I've also seen actions arise where there's a decision to completely change the direction of the company, perhaps to enter in a new business which could be more risky or move away from a profitable line of activity. And it may also result, and again this is quite common, from some sort of attempt to change the constitution of the company in a way which may, in the short or medium term, prejudice some of the members. And there's extensive case law on all of these sets of circumstances. I think importantly it's not necessary for there to have been a breach of the director's duties that Stephen took you through earlier for an unfair prejudice claim to be brought. And where such a claim is brought, the court does have very broad powers indeed on how it sorts things out. It can order shares to be bought or sold at a value, it can remove directors, and it can order transactions to be unwound if practicable. As I say, these disputes can arise in many circumstances, but I think the single most practical way of avoiding these disputes is to ensure that you have a shareholders' agreement in place which properly regulates the interrelationship of shareholders and the way in which they may deal with and affect decisions of the management. Very often, the underlying issue, as I say, is a dispute between shareholders where some control the board and others don't. And if you thought these issues through in advance in a shareholders' agreement, that can often sort out the problem. Well, we've come to the end of our formal session now, and I was going to ask if anybody's got any questions. I think we've got one or two here. Let's look at this. The first one is so the first we've got here is for Stephen. So I'll just read this out. So I've got a question for Stephen relating to his comments about the Deutsche Bank case and directors' liability for a company's legal costs. Does that mean that it's dangerous for a shareholder or director to put money into a company by way of loan or investment in order to help the company defend litigation when the company couldn't otherwise fund that litigation but is otherwise trading profitably?
Yes, it's a very good point. And there isn't, I'm afraid, an absolute black and white answer to this. The starting point is that third-party cost orders, like I mentioned in the Deutsche Bank case, are the exception to the rule. So there needs to be exceptional circumstances in which for such an order to be made. The court will have to consider various factors. In Deutsche Bank, it was all quite extreme because there were such huge sums involved, and clearly it was for the obvious benefit of the director and shareholder. But the court will need to think about, firstly, whether the intended respondent to the third-party cost order application could have been joined to the litigation as a party and have a chance to defend themselves directly in that litigation. The court will also think about whether the respondent was really pulling the strings in the background or there was someone else directing it. And the court will consider whether a warning was given at any stage that if the company couldn't satisfy a cost order, an application for a third-party cost order be made. Now, if all of those boxes are ticked, then yes, there is a risk in those circumstances a third-party cost order could be made.
Thank you, Stephen. Let me see, what have we got? Okay, I think this next one is for you as well, probably. You mentioned directors going to prison for contempt. Can a director be sent to prison if a company breaches any other court orders?
What was particular about the two cases I mentioned, they both involved injunctions. The nightclub case was an injunction preventing the company playing music, and the other case involved a worldwide freezing order, which is also a sort of injunction. Injunctions are particularly powerful court orders, and they have on the front of them what's called a penal notice, which is essentially in very big capital letters a warning that if you breach the order you will go to prison, and that doesn't extend to normal run-of-the-mill court orders. So in short, the answer is no. Normal court orders won't carry that consequence for directors.
Thanks, Stephen. We've got one more question here, which I think I can probably answer. It's as follows. So your talk has covered claims by the company against directors and derivative claims brought by a shareholder for the company. Are there circumstances in which shareholders can bring their own claim against the directors or the company? There are actually two questions in there. I think the first is claims by shareholders against the company, which is slightly outside today's talk, but there certainly are situations in which you can imagine that happening. So, for example, if a shareholder's rights under the Articles of Association have been breached, then that would definitely give rise to a claim against the company. But as I say, that doesn't relate directly to directors. More generally, it's certainly possible for directors to get sued by their shareholders, and I was thinking about this in a different context earlier when preparing this talk. The most obvious example, I suppose, is the ongoing RBS litigation. Most of you may be aware of the shareholders' claim against RBS. The shareholders are complaining that just before the crash, RBS raised a very large amount of money, I think some billions, by way of a rights issue, and the company's being sued, and a number of the directors, including Fred Goodwin, are being sued for many, many billions, I think, of pounds on the grounds that they were misled in the investment documentation to putting their money in. So that's a good example of a case where shareholders, in this case a shareholders action group, but representing the shareholders, is bringing a claim not just against the company but against the individual directors. I think that's still going on, so it'll be interesting to see how it pans out. I think that's all the questions that we've got today. If you've got any further questions arising out of today's talk, then you can see our email addresses there on the screen, and we'll be very pleased indeed to hear from you and endeavour to answer. If you've got if you'd like to see the slides, then do let us know. And we'd be particularly interested to hear about any subjects on which you'd like to have future webinars from either us or our colleagues elsewhere here at Clarkslegal. So thank you very much indeed for listening today. I hope you've found our talk informative and have a good afternoon. Thank you very much.